There is question about the recent case law of Sony versus Ilayaraja.
Probably you know that Mr. Ilayaraja, one of the most respected original music composers, has been one of the few South Indian music directors to assert his copyright in his works, in compositions, even after they were composed for the films, and even after he assigned the copyright in favor of music companies. I was reading long back a 2015 judgment of Madras High Court, where the High Court upheld his contention, saying that he assigned the copyright in all his music compositions to his wife. His wife assigned it to some other company, and that some other company enjoyed for 5 years, but continued to exploit the copyrighted musical work even after the expiry of 5 years. Here, 5 years is important because Mr. Sooraj Gemini has already explained under Section 19, Clause 5, if no specific term of assignment is mentioned, it is presumed to be 5 years. He says, yes, 5 years you have enjoyed. Therefore, in fact, after that, you cannot enjoy, the copyright comes back to me. And his contention was upheld, but there are a number of episodes since 2015. There was a time when two music greats, in fact, confronted each other, S.P. Balasubramaniam and Ilayaraja, especially when SPB was on a world tour. He sent a notice, and then ultimately there was a settlement. That's different issue. Coming back to this March, a suit filed by Sony Music versus Ilayaraja, again, it is like a counterblast kind of thing, continuation of the previous episode, which I explained already. And point is very simple. After 2012 amendment to the Copyright Act of 1957, certainly the music composers, the authors, the lyricists, and the like, their in fact, position has got strengthened. And then the music company started probably a counter, in fact, against these people. It's counter blast, you can say. Sony's case also can be considered as the same. Let's wait for the decision of the Bombay High Court.
Now, there is one question from Mr. Ritvik. Sir, does fair use have some exceptions?
Here the entire idea with respect to fair use principles is that obviously the work has to benefit. I will give a general explanation to that. The work has to benefit individuals or the public at large. So therefore, whenever some use is actually just and reasonable, for example, the use of this work in a particular educational setting, or maybe allowing students to see it, maybe for criticism, or maybe for review, etc. In such kind of situations, we can understand that the fair use principle sets in. So therefore, there is invitation, no penalties or actions against that is attached with respect to what is the scope of the act.
From our side, when the registration of copyright is not mandatory, why to register the copyright?
Yeah, entirely, we can understand that, there are certain situations in which two individuals also might have individually, irrespective of the fact that they have seen each other or anything like that, may claim copyright, may have produced the same things at the simultaneous period in time. So therefore, registration of this copyright actually does not preclude any other person from claiming a copyright. So therefore, if a copyright claim, or if there is an argument with respect to that, it has to be decided by the registrar, and as well as that, if there is an appeal, it might lie to the appellate board, which can decide on these issues. So therefore, the registration of the copyright is not a mandatory thing under the Act. Okay. A person may decide to register it under the Act, and he may give the particulars regarding all his particulars, etc., and that might be entered into the register. But generally, just because of the fact that some registration has been done does not actually give a conclusive evidence of the fact that you are in possession of the particular copyright. And also, we understand that passing of principles are also attracted here because sometimes there is a misrepresentation, etc. And just similar to other intellectual property rights, we can see that the passing of action also lies in the case of copyright. So therefore, there might be a case in which somebody has a copyright, another person has also produced a similar thing, and there is no copying or there is no gaining from the other one. But then there might be a claim. So therefore, these kinds of claims also have to be introduced, and because of this, we can understand that there is no conducive presumption of claim just because of the fact that somebody has registered. That means that this copyrights entirely subsists with him, and he is able to make the right.
Thank you, sir. There is one more question, sir, from our side. Sir, what is your opinion on the recent Sci-Hub case relating to copyright and piracy?
Yeah. Basically, we can understand that copyright law, its manifestations, etc., are of great importance in jurisdictions like the United States, where a lot of money is involved in this kind of activities. In India, we have a more welfare as well as a social jurisprudence at work. So therefore, we understand that there are certain sites like SkyHub, Elixir, etc., that actually allows researchers to gain access to publications for free, which are that particular website has been made by I think is a Ukrainian or Russian woman who has actually put up those sites because she has a particular kind of algorithm that she uses for this particular, giving away these particular things for free. Now, one thing we have to understand is that when we have a university or an institutionalized research system and we have researchers producing works and they like to gain recognition, fame, or maybe they like to throw open their work to others, so maybe to invite criticism or for the betterment of science. The universities may actually stipulate for publications or maybe stipulate a number of publications in a particular journal. And we understand that most of the time Indian universities insist on peer-reviewed publications. And others also gain fame because of the fact that they have published in a foreign journal and they say that that impact factor is there, this impact factor is there, the H citation index is so much, this thing and all. But actually the entire thing is speculative. The reason why it is speculative is that these publishers, for example, I might quote a few examples like Science Direct, Elsevier, and certain other sites which actually charge a lot of money for somebody to download a paper from their site to view it. Now, actually, the research is not funded. It is not actually financially supported by these kind of publishers. It is the universities in India. If we are taking the Indian system, we understand it is the universities in India that actually fund this research. Now, when we give up these papers for publication, we are actually, they would they would, on the basis of the contract that they give us, they tell us that we have to waive all the rights to the publisher. He takes up the publication, and this publication is held by him as a he owned it, and then he sells the publication for a hefty fee. To my knowledge, every single paper that you can get is priced around 30 to 35 US dollars, which no scholar in India can actually afford, because you will have to go through multitude of papers before you can find the right one. Even before opening the paper itself, how is it possible to understand whether this particular paper is useful to us or not? They might give an abstract, and in the abstract they will not give any details. So only after you open the paper, you understand that barely there are certain peripheral words which are of interest to you, but it does not have any bearing to what you really want. So this case, which is instituted in the Delhi High Court, is to create a permanent injunction in which that any sort of algorithm which is produced by this lady through SkyHub is not applicable, in the sense that we cannot access it. And the detriment is created when we cannot actually access these particular papers or download these papers, and the science or the betterment of science is actually impeded. And what happens is that the publisher here is making money in a fraudulent manner. I would say that it is one of the most unethical things that we can ever do, because these publishers don't spend a penny in order to publish these things. In order to acquire the rights of these, the fruits of the research. And the poor Indian scholar is left at the mercy of these people. If SkyHub is closed, or if the Delhi High Court were to pronounce an injunction the poor Indian scholar would be at a great loss because they would have nowhere to access these papers. Actually, the entire regime is about minting money. And we know that IPR actually stands in stark contrast to human rights. And we say that IPR and human rights are always at loggerheads because it negates human rights principle, whether it is in case of pharmaceutical products or whether it is in case of obligations which are of benefit to education. So there has been a lot of weight which is given behind this case, and the Delhi High Court was urged by not to come up with an injunction to prevent these people from accessing these sites because there is no other way. The Elsevier or Science Direct or anybody, they don't spend any money for the fruits of the research that we put in over there, and they are actually making millions of money by actually taking it for free and getting it published by them, and thereafter charging money in a hefty manner. So I think that it is a step in the right direction that the Delhi High Court has been hesitant to come up with a firm decision with respect to this. It is actually the case is being considered by the High Court there, and we pray that something nice comes out. And just like in the former pharmaceutical cases we have in patent law, so the court comes up with some fine principle whereby private and public interests are actually weighed and some weightage is given to the needs of betterment of science and research in India.
Thank you, Suraj sir,
Thank you, sir.
for the detailed reply about this case. Now I request the DPIIT IPR Chair Professor GB Reddy sir to please continue with the proceedings.
Once again, very good evening to all. I've been listening to the lecture delivered by Mr. Sooraj Gemini during the last 1 hour plus. And I found that Mr. Gemini has made his homework very well and presented the lecture, not only on the conceptual aspects, but also on the emerging areas as well, including the physically disabled exception. Mr. Sooraj Gemini has made a wonderful presentation because we can't build superstructures without a strong foundation. And he was trying to, in fact, refresh our memory regarding the basic concepts of copyright. And in a very beautiful and, beautifully flowing lecture, I thank him for associating himself with our endeavor. And we wish to have his association in many more, assignments in future.